This is one of those stories that sounds technical at first, almost boring, until you realize what it's actually about: power, control, and who gets to decide how Americans heat their homes and cook their food. I'm Donald Douglas, and on this channel, we take major legal and political stories and slow them down enough to understand what's really happening. Today we're talking about why the U.S. Department of Justice has sued multiple California cities over their bans on natural gas in new buildings, what the federal government says those cities did wrong, and why this case could affect far more than just California. This isn't just about gas stoves, it's about how much authority cities actually have, where federal law steps in, and what happens when climate policy collides head-on with national energy rules. Let's start with what happened. Earlier this year, the U.S. Department of Justice filed a lawsuit against two California cities, Morgan Hill and Petaluma. The DOJ argues that local ordinances passed by these cities, which restrict or effectively ban natural infrastructure in new construction, violate federal law. The federal government is asking a court to block those ordinances permanently and declare them invalid. The argument is straightforward from Washington's perspective. Energy regulation, especially when it comes to appliances and efficiency standards, is largely governed by federal law. Cities, the DOJ says, don't get to override that framework just because they want to pursue aggressive climate goals. The cities, of course, see things very differently. For years, California municipalities have been pushing building electrification as a way to reduce greenhouse gas emissions. Natural gas is a fossil fuel. Burning it releases carbon dioxide and other pollutants. From the perspective of local leaders, moving new buildings away from gas and toward electric systems powered by an increasingly renewable grid is a logical step. Morgan Hill adopted its ordinance back in 2019. Petaluma followed with its own all-electric building code a few years later. These policies didn't usually ban gas outright with a single sentence. Instead, they used building codes, permitting rules, and infrastructure restrictions that made gas hookups impractical or impossible for most new construction. Supporters called it climate leadership. Critics called it an end run around federal law. That criticism became much louder after a key legal development. In 2023, a federal appeals court struck down a similar natural gas ban passed by the city of Berkeley. The court ruled that Berkeley's ordinance was preempted by federal law, specifically the Energy Policy and Conservation Act, often shortened to EPCA. That law gives the federal government authority over energy efficiency standards for appliances like furnaces, water heaters, and stoves. The court said Berkeley couldn't do indirectly what it wasn't allowed to do directly, which was restrict federally regulated appliances by cutting off their fuel source. After that ruling, many California cities paused enforcement of their gas bans. Some stopped enforcing them entirely, but left the laws on the books, and that's where the Justice Department stepped in. According to the DOJ, even unenforced ordinances create uncertainty, discourage development, and signal future restrictions. From their point of view, leaving these bans in place continues to interfere with national energy policy and consumer choice. So, the lawsuit was filed. Now, let's talk about what the federal government is actually arguing, because this is where things get interesting. At the heart of the case is federal preemption. When Congress passes a law that regulates a specific area, states and cities generally cannot pass laws that conflict with it. The Energy Policy and Conservation Act sets national standards for energy use and efficiency. The DOJ argues that by effectively banning gas appliances in new buildings, these cities are interfering with a field that Congress already occupied. The federal government also frames this as an economic issue. Their complaint argues that gas bans limit consumer choice and raise housing costs. Builders, they say, are forced into more expensive systems. Homeowners lose the ability to choose appliances they prefer. And in areas where electricity grids are strained, relying solely on electric systems could reduce reliability. This lawsuit is also tied to a broader federal push to reassert national energy policy. The DOJ's filing aligns with executive actions emphasizing energy independence and opposing regulations that restrict fossil fuel use. From that perspective, local gas bans aren't just climate policies, they're obstacles. California cities counter with their own arguments. Local governments traditionally have wide authority over building codes, zoning, and land use. Cities argue that they are not regulating appliances themselves, but rather setting standards for buildings in order to meet safety, environmental, and climate goals. They say federal law sets minimum efficiency standards, not a mandate that gas must always be allowed. They also point out something important. Even before these bans, many developers were already choosing electric systems voluntarily. Heat pumps have improved. Electric appliances have become more efficient. In some markets, all electric buildings are already the norm. From the city's perspective, the federal government is stepping in to solve a problem that doesn't really exist. But courts don't decide cases based on intentions. They decide them based on law. And that's why this case matters beyond California. If the DOJ wins, it could sharply limit what cities across the country can do when it comes to regulating fossil fuels in buildings. Dozens of cities, not just in California, but nationwide, have passed or considered similar electrification policies. A ruling against Morgan Hill and Petaluma could chill those efforts overnight. On the other hand, if the cities prevail, it could open the door for more aggressive local climate policies, even when they indirectly affect federally regulated markets. That's the larger tension here. Climate change policy in the United States has increasingly moved to the local level because Congress has struggled to act comprehensively. Cities and states have filled the gap. This lawsuit is a reminder that federal law still sets boundaries. There's also a political layer to this. Energy policy has become deeply polarized. To some, natural gas is a bridge fuel that provides reliable energy while renewables scale up. To others, it's a fossil fuel that should be phased out as quickly as possible. Local gas bans sit right at the intersection of that divide. What makes this case even more unusual is that the cities aren't accused of enforcing their bans aggressively right now. In fact, both Morgan Hill and Petaluma have said they have approved projects with gas hookups since the Berkeley ruling. But the DOJ argues that leaving the ordinances in place still matters. Laws on the books can shape behavior, influence investment, and signal future enforcement. The federal government wants clarity, not ambiguity. So what happens next? The case is still in its early stages. The cities can file motions to dismiss. They can argue that their ordinances don't actually conflict with federal law, or that the DOJ lacks standing. The federal government will respond. Eventually, a judge will have to decide whether the case moves forward and whether to issue injunctions. If the district court rules decisively, the losing side will almost certainly appeal. That means this case could end up back before the Ninth Circuit, the same court that decided the Berkeley case. Depending on how far it goes, it could even reach the Supreme Court. And that's why people on both sides are paying attention. For climate advocates, this case is about whether local governments can continue to lead when federal action stalls. For energy producers and builders, it's about consistency and predictability in national energy markets. For the federal government, it's about enforcing laws Congress already passed. For everyone else, it's about something more practical. How much choice do you actually have over how your home is built and powered? This lawsuit doesn't answer that question yet, but it brings it into focus. As with many legal battles, the outcome will likely be narrow on paper and broad in impact. A few paragraphs in a court opinion could influence building codes, energy planning, and climate policy for years. That's why this story matters. Even if you don't live in California, and even if you've never thought much about natural gas before. Because when local ambition runs into federal authority, the result shapes what governments can do next. I'll be following this case closely as it moves through the courts, and we'll revisit it when there are major developments. If you appreciate deep dives like this, where we focus on facts, context, and consequences rather than shouting matches, make sure to subscribe to the channel. It helps more than you might think, and it lets you catch future updates and breakdowns as they happen. I'm Donald Douglas. Thanks for watching, and I'll see you in the next video.